We'll discuss now only. Okay. Tuck. We'll discuss of 15 minutes. Okay. Now, people, what are the question? There were 3 questions in total. The first question, Mr. Naman is an auctioneer. He advertised in a leading newspaper that an auction would be held on 17th April 2025 in Agra for the sale of some office furniture. Mr. Kanha read the advertisement and travelled about 500 kilometers to attend the auction. When he reached the place of the auction, he found that the furniture had been withdrawn from the sale. Mr. Kanha sued Mr. Naman for the loss of his time and expenses. State with reasons whether Mr. Kanha can claim compensation from Mr. Naman under the provisions of Indian Contract Act 1872. Why? Provision. So, as I say always, 3 paragraphs. The first paragraph has to be law. That means it has to be provision. Second paragraph has to be fact. Third paragraph has to be conclusion. Always remember, your conclusion may be right. If your paragraph is wrong, your answer is wrong. Again, I'm telling you. For example, you just said, will he succeed? You said no. But if your provision is wrong, but your conclusion is right, you won't even get 1 mark. Provision in the sense, according to what you are saying, Mr. Kanha will not win the case. So that is what is called provision. Provision means you are writing the answer according to what? It cannot be just an assumption. You need to substantiate your answer. Substantiate means there has to be some evidence. Based upon this, I am telling that he will not win the case. That is very important. Now again, why I am telling this to you is, that is another myth that we have. What is that? Sir, if I write conclusion right, but still they have deducted the marks for me. People, conclusion is even an elementary school person can write, because the answer is so simple. Whether Kanha will win the case or not win the case. Do we need even knowledge to write that? It can even be pure luck, no? Writing yes or no will never get even 1 mark until your provision is right. Provision is law, the first paragraph, the opening paragraph. Getting the point? Okay. Now what is the answer? According to Indian Contract Act, which section now? No section here, because invitation to an offer did not had a section as such. They just gave us that it is different from the offer. So whatever is the scenario, the provision is, as per Indian Contract Act, an invitation to an offer does not create any binding contract, and an invitation to an offer is different from offer. All the advertisements, public notices, auctions will always be an invitation to an offer and not offer in itself. Based on that ground, in the given case, whenever I say that I will be selling a particular article in an auction, I'm just giving an invitation to an offer. It's not an offer. So on that day, if I did not sell that article, it does not bind anything there. You cannot file a case on me. No, you will succeed. Answer is no, you will not succeed. So how will I frame my answer? My first paragraph has to speak about invitation to an offer. My second paragraph has to speak about the same question. Split it into points. Hello? Now this has been taken from ICAI only directly. Now see how they write. First one is paragraph, that is provision. What is second one? Second one, see what are they telling you? In the instant case, Mr. Naman advertised for sale of some office furniture in an auction in Agra for some. Mr. Kanha read the advertisement and travelled about 500, but he found that furniture was withdrawn from the sale. Mr. Kanha sued against Mr. Naman for loss of his time and expenses. Don't you think that is what is given in the question? Then that's what I say. This is always facts. Facts, there is nothing. It is again rewriting of question in short. See, 4 line, 3 line. Conclusion. On the basis of above provision and facts. Don't you think that is a format we wrote? Based on the facts and provision, advertisement of auction by Mr. Naman is not an offer but merely an invitation to an offer. He is not liable to Mr. Kanha. Hence, Mr. Kanha could not succeed in his suit. Hello? Hello? Getting the point? So, I will write here in this way. Whether Mr. Kanha can claim compensation from Mr. Raman I'll write no, Kanha cannot claim compensation from Mr. Naman because it is just an invitation to an offer and not an offer in itself. Hello? Done? Yes? Hello? Done now? What you guys can do is, as I'm telling you, have you guys written it? All of you? Do one thing, exchange your papers and correct it. Who and all have written? Okay, can you guys exchange your papers? Shravya, you give it to Abbas. Abbas, you give it to Shravya. Can you guys do it the same way?
All the three questions.
Whatever you guys have written, everything. That's okay. Give it. Arnavan, what is your name? Sopam? Sopam and Arnav, and who else? You wrote? You, why? You didn't write? Okay. Why? Okay. So, based on that, check for the provision. All three questions were 5 marks. Now, how the evaluation is done? Now, I just told you, check for the provision. If invitation to an offer was there, if provision is right, you will get 3 marks. So, in the same answers, check if provision is there. If provision is there, give 3 marks. Wrong. Now, let us imagine if it's a 5-mark question. Your provision is right. You may get 2 marks, you may get 1 mark. But your conclusion is wrong. I mean, your conclusion is right. Your provision is wrong. You hardly will get even half a mark. Yeah? So, again, if provision is right, give them 3 marks. If conclusion is also right, and then facts are also right, then give them another 2 marks. But remember, invitation, they should have written everything. If they just written an invitation to an offer and nothing else, give the mark accordingly. If everything is written 3, if nothing is written 2, if nothing completely in detail is not written, then give 2. It is just written on the face of it, then just give 1 mark. Done na? Arnav, done? Yes, okay, next one. Mr. Sharma, trader, wrote to Mr. Verma offering to sell him 100 barrels of oil. I would say this is difficulty level question. It could have been difficult, but because of being in detailed, I would say this is moderate. If not, this is capable of being difficult question. Okay, Mr. Sharma, trader, wrote to Mr. Verma offering to sell him 100 barrels of oil at 5,000 rupees per barrel. The letter reached Verma on 1st June. On 2nd June, Sharma posted another letter revoking the offer. The letter reached Verma on 1st June. On 2nd June, Sharma posted another letter revoking the offer.
So the offerer posted another letter for
revoking the offer. I have sent first letter saying I want to sell. I have sent another letter I don't want to sell. That has reached second. That is what they are telling you.
So but the first letter have been reached to Verma.
The letter reached Verma on 1st. On 2nd June, Sharma posted another letter. They just said it, he is posted. However, before receiving the revocation, Verma posted a letter of acceptance on 3rd June. So what has happened? Sharma sent the first letter on 1st June, which is reached also. He has sent first, this is second letter. He sent it on 2nd June. Now Verma has replied to this letter on 3rd June. Which letter? The first letter. He has replied it already. Revocation is not yet reached. Okay. Sharma's letter of revocation reached Verma on 4th June. See, this second letter has now reached Verma on 4th June. I hope it is clear. You guys go, this one was a top bouncer, or you guys were able to write it? Okay. When Verma later demanded delivery, Sharma refused, stating that the contract was void since he had not specified which kind of oil was being offered. See what is happening? When Verma later demanded delivery, Sharma refused, stating that the contract was void since he had not specified which kind of oil was being offered. Yes, sir. And further claimed that he had no oil stock at all. Verma sued for breach of contract, insisting that valid acceptance had already been communicated. Sharma defended himself by stating that contract was void for uncertainty and impossibility. Examine the relevant provision of Indian Contract Act 1872 and decide whether a binding contract was created between Sharma and Verma and whether Sharma is liable for damages.
No.
That's the question. I would say this can carry probably 6 marks also.
Yes, sir.
Yes. Now,
Because two incidents have been insisted in this question. One is that offer of acceptance, that is revocation, section 4, and then so according to the elements of the
Lack of information.
lack of information, that is thirdly not vague.
Not vague.
vague.
Under section 10.
Correct. Now you guys will be writing in provision. You will be writing this in provision. What is that? One people. There are two provisions now. I hope it is clear. First provision is in the answer they are talking about whether there is an valid contract between them. See, first the question is acceptance is valid.
Yes, sir.
He has given it valid. So according to section 4, when does the offer and acceptance, when does they come to an end? When do they become complete? We saw that letters and all. When, how, all those things. So whenever an offer is written, whenever an acceptance is given, matchstick that it has burnt, revocation reads later. Now what should I write? Acceptance, when is it complete? For the proposer, when is it complete to the acceptor? Hello?
Yes, sir.
So from the acceptors, from the proposer's point of view, that is from Sharma's point of view, when is acceptance complete? When the letter was put in the course of transmission only, acceptance is complete. Now can I revoke? Answer is no. Hello? Agreed? Now I need to write that entire provision for this particular part where it says whenever there are so many letters being exchanged. So according to the letter theory, yes, he has given his acceptance and that acceptance is valid. However, according to the essential elements, an offer has to be always certain and it should not be vague. Now here in this, they have clearly said 100 barrels of oil. Now why did I say I could have given this question as a difficult question, but why did I say I would give it as moderate? Because they have only said this point. Where? This one. He had not specified which kind of oil. If this word was not there, I would have given this question as difficult level. Now your mind should have thought in the exam. Yesterday I told you my son's theory. Triangle, square, both is there. Correct? Now why am I putting the triangle in the triangle shape? You need to write. Both the provisions are there. Now it is your mind which had to figure out. Because of this I am telling that it is valid or invalid. Now because people, which kind of oil it is not prescribed. So based on that I am telling you it is a void contract. It's void agreement because the offer was vague. It was not certain in nature. So based on that, can I, what is that? Who can succeed? Sharma defended himself by stating that contract was void, uncertain. Yes, people, it was uncertain, and Sharma is not liable to pay any compensation to Mr. Verma.
Answer one more point. Mr. Verma accepted before that revocation.
Correct. That is what I answered. No, acceptor. When is the acceptance complete? Against the proposer, against the acceptor. Your point should say against the proposer, acceptance is complete. When the acceptor puts the acceptance in the course of transmission, that word should be there. Hello? Yes, Sam. Yes or no? Hello? Pakka? Okay. So how will you give it? Now see, if all those things are there, give 6. Now go and start seeing whether those things were there. They just wrote acceptance is complete. They did not completely write the provision. Then deduct 2 marks. if they did not write the next part, what is the next part?
Facts.
The certainty and all of that. If that was not written, deduct another 2 marks. The main 2 provisions are important. And then yes, conclusion, of course. For the conclusion, give 2 marks.
So what is the conclusion of that?
Conclusion is Sharma cannot, Sharma will succeed in the case. He is not liable to pay any compensation.
Not a valid contract.
It's not a valid contract. It's not a valid, cannot claim damages.
So we can mention that under essential elements in section 10.
So not under section 10.
Sorry, not under section 10. It is not like lack of information, certain but not there.
Correct, yes.
So conclusion is wrong. How?
Conclusion is wrong, but provision is right.
Provision, one provision. is right.
Then just give 2 marks overall. Yes, sir. Now, last one, people. Mr. Das, a landowner, transferred his property to his daughter, Geeta, on the condition that she would pay 20,000 annually to her maternal uncle, Mr. Gopal. Geeta accepted the property but later failed to pay the annuity. Mr. Gopal sued Geeta for recovery. Geeta argued that since Gopal was not a party to the agreement, he had no right to sue. Gopal contended that the consideration had moved from Das on his behalf and that he was entitled to enforce the promise. Examine whether Mr. Gopal can recover the annuity under Indian Contract Act 1872.
Yes.
Yes? How? What is the provision?
The privity of contract, the family settlement exception is there if that like third beneficiary can.
Very good. The provision that you guys have to look out for is, people, the provision should clearly say doctrine of privity of contract has certain exceptions. In that exception, people, you should have written acknowledgement.
And estoppel.
Acknowledgement or estoppel. There, which was a case law. The entire story is similar to some case law. Chinnaya versus Ramaya. Now, what did our book say? If you don't write case name or section, not required. No, see, guideline answer.
Sir, I have not mentioned this in answer.
Yes, that's what I'm saying. Now, why I'm saying it this way is they will write. See here, how guideline answer is coming then? See, I'm not saying they are clearly giving you a notification. You're not expected to write section numbers and case law. They are not going to deduct mark. They are telling you correct. But I am telling you, when we are practicing, let us try to practice with section numbers and with this one only. Hello? Yes? Now, how is that they are writing you? Remember, people, I need to write 2 things here. First thing, you need to write the definition of consideration. What is the definition of consideration? Section 2D says. What does section 2D say? What is consideration? So, when at the desire of the promiser, promisee or any other person. That's the definition. In this case, that is what is happening. No, promisee or any other person is giving on behalf of the person. I did not give, but my brother gave is what this person is saying. So I will be writing section 2D. And I'll be mentioning privity of contract exception. Hello? So if these 3 words are there, give them. If not, don't give them.
So can we write consideration must move at the desire of promission?
Consideration must move at the desire of the promiser, correct? But in this case, what is happening? I did not give. Someone else gave the consideration on behalf of me. That point is communicated where? Consideration may move from promisee or any other person. That's the second line of consideration definition, no? Yes or no? So, out of 5 marks, if provision is right, the provision has all 3 words. Consideration definition, next one is privity of contract and exception. If all 3 are mentioned, then give them 3 marks. Privity of contract and the other one is written, then give 2. Yes? Because if you just actually logically, if you think, if you just write privity of contract and if you leave it, that means you are telling the third party cannot sue. It becomes opposite.
So exception.
You should write exception. If not, the answer itself is wrong.
Please, sir.
Again, same thing. Triangle, square. When there is a similar and decided case law, Chinnaya versus Ramaya. That's why it does not go under family settlement.
So it is estoppel or acknowledgement?
Estoppel or acknowledgement. Why again family settlement is not coming? Paying pension is never part of any agreement, no? Family settlement is a property dispute settlement. Yes?
It is other than property dispute.
Correct. And the better one is acknowledgement or estoppel. Clear?
Its promise can't withdraw. Estoppel.
You cannot step back.
Yes.
Whatever you have agreed to do, you cannot step back. Yes? So overall, check how much you guys have got. Clear? Okay. So people, that's why I say, now you tell me how much time did it take for you to understand and write the questions? Again and again I'm telling you, in law there is no shortcut. You read 100 times. You write 5 times. The person who writes 5 times will clear, not the person who reads 100 times. And this is true. Are you getting it? Yes. So again, we'll see in the tomorrow's thing.